you all for being here and providing coverage for this important issue. In 2018, the Massachusetts State Legislature passed and Governor Baker signed a landmark criminal justice reform package. Contained within the law were many positive and constructive reforms and policy changes, including greater accessibility for record expungement and sealing, more humane solitary confinement conditions, stronger opiate trafficking conditions or penalties, the elimination of mandatory minimum sentences for many low-level drug offenses, and the increase of the minimum age of criminal responsibility from age 7 to age 12. Also, however, contained in the 2018 Criminal Justice Reform Law was the establishment of medical parole here in the Commonwealth of Massachusetts, which allows for the release of a prisoner due to terminal illness or permanent incapacitation. That's the language of the statute. This statute directs, in the case of inmates in state prison, that this decision is made unilaterally by the Commissioner of the Department of Corrections. This places the Commissioner in the position to single-handedly void a sentence that was litigated and eventually rendered by a Superior Court judge. In most cases, after years of litigation, a dissection of the evidence, and a plea or a jury's conviction. This enormous responsibility can be carried out in mere days and many times without even a hearing on the facts of the incapacity or illness that is argued. This law has come to apply to all sentenced inmates, including those serving life sentences for first-degree murder convictions. The law does not apparently exclude or otherwise distinguish these inmates whose sentences represent the most serious punishment our laws allow, which explicitly preclude the possibility of parole. There is no doubt that those convicted of first-degree murder have committed a most egregious act in the taking of another person's life with a specific intent to do so. Under the laws of the Commonwealth, first-degree murder, and only this charge, directs that these individuals are sentenced to life without the possibility of parole. Although it may first appear that justice is rendered through the court system in cases ending with a conviction, families soon come to realize that the fight does not end there, and that justice is not indelible. Soon thereafter, seemingly endless appeals and motions come like the seasons, year after year. Their fight for justice never ends, and the pain never subsides. Since these changes to the state's medical parole law went into effect, the Hampden District Attorney's Office has been notified by the Massachusetts Department of Corrections of 45 petitions for medical parole. Of those 45 petitions, nearly half, 21 of those petitions, have been made by inmates convicted of murder. Some of the reasons cited in their petitions for this early release, purportedly to establish a, quote, permanent incapacitation as the statute directs, have included hypertension, the need for a wheelchair, pre-diabetes, insomnia, obesity, COVID-19, and back pain. Members of my office often serve as the voice for victims and their families who don't have an opportunity to speak for themselves. However, today, we have two people and family members who can speak for their lost loved ones and about how this process has affected them and their families. In January of 1982, Anthony Olszewski murdered 19-year-old Joanne Welch. Olszewski committed the crime in a particularly heinous fashion, later telling friends that, quote, she just wouldn't die. Joanne was a fighter and managed to stay alive through this brutal assault, only succumbing after Olszewski left her in a remote location in the middle of winter where she died of exposure. Olszewski was convicted of first-degree murder, which was later overturned by the SJC. His case was retried and he was convicted a second time of murder in the first degree. To this day, 40 years later, he continues to contrive post-conviction motions and appeals on both the state and federal levels. The Welch family has endured 40 years of Olszewski's virtually relentless attempts to undo justice. With regard to medical parole, Olszewski has filed 2 medical parole petitions in 2020 and 2021. Fortunately, both of those were denied. John Stote brutally stabbed and killed John Regan in 1995. He was tried and convicted in 1997 and has since filed numerous post-conviction appeals, leading to dozens of motions and hearings. Through these court events over the past 25 years, his family has had to constantly relive the tragic killing of their loved one every time that they are notified of another motion being filed or hearing being held. Stote has filed 4 petitions pursuant to the medical parole statute, specifically 3 medical parole petitions, 2020 and 2021. He also filed 1 petition to the Suffolk Superior Court in 2020. He was released now twice. His first release was revoked by the parole board, since the basis of his first release was that he was terminally ill with COVID. He survived that period of time and lived outside of incarceration until such time the parole board finally stepped in and reincarcerated him. He filed another petition to the Commissioner of DOC under the medical parole statute. That was denied and then appealed effectively to the Suffolk Superior Court in Boston, where a judge essentially directed the commissioner to reconsider her decision that he found arbitrary and capricious, and essentially forced her hand to release him again. Mr. Stote has been out for a lengthy period of time under that release, effectively by the Suffolk Superior Court and ultimately by the Commissioner of the Department of Corrections. In 2004, Joanne Sleech Brodeur stabbed her husband, Joseph Brodeur, 34 times, fatally wounding him. She was convicted of first-degree murder, which was then overturned on appeal. She eventually pled guilty to second-degree murder and admitted to killing her husband. Ms. Sleech Brodeur has filed 3 medical parole petitions, 2 in 2020 and 1 in 2021. Fortunately, all of those have been denied. At this point, I invite Jim Welch to speak about his family's experiences with medical parole.
Well, good morning, and thank you to District Attorney Gulluni. His willingness to stand up for victims and victims' families certainly does not go unnoticed here, obviously in Western Massachusetts, but really across the state. It's not always a popular stance in today's climate to support and stand up for victims, but you do that constantly. And I want to thank you on behalf of our family. Today I'm joined by my cousin Patty, my cousin Paula, her husband Dan, and my brother John. I'm the cousin of Joanne Welch. I was 6 years old when the murder happened, and I just speak a little bit about, you know, as the DA had mentioned, just the year after year after year, you know, attempts to appeal, attempts to do whatever he can to get out of jail. Do, say, and attempt anything to get out of jail. And the latest, unfortunately, is his attempt to use COVID-19 as a medical reason to be released on medical parole. Now, the medical parole law, as the DA had mentioned, was a well-intentioned law. If someone is at the end of their life, if they're terminal, if they are, a doctor determines them that they do not have long to live, medical parole would then step in. Medical parole is not supposed to be used for people to take advantage of a loophole and to apply to be released early based on, you know, maybe something that isn't necessarily in the guidelines. But what this does for families, and I can speak for our family, is every single time that an appeal comes up, every single time that a motion comes up, my cousins and us and the whole family, we have to relive that trauma. Every year. It's been 40 years since I was 6 years old. I grew up with this. And he'll do anything to try and get out. He'll do anything to continue to make the lives of my cousins and my extended families, very, very difficult. To relive that trauma, to relive it on an almost yearly basis, is something that no family should have to go through, and especially a family, obviously, that has dealt with this type of trauma. One of my cousins, I think, described it as generational trauma. So this isn't just trauma that, unfortunately, my cousins and sisters of Joanne experienced, but now their children, and now there's another generation that's dealing with it as well, being told about the story, being told about what happened, being told about the person who tries to get out of jail. So it's now multi-generational, the trauma, and it's just something, and I, again, applaud, and I'm proud to stand with the other families that are here today as well, to do what we can to fight to make sure that this legislation passes and that this loophole is overturned, and make sure that life without the eligibility of parole means life without the eligibility of parole. Thank you. Thanks, Dan.
Now invite Maureen Regan, daughter of John Regan, to speak to her family's experience.
First of all, thank you very much, District Attorney Gulluni, for inviting all of our families here today, and for inviting me to speak to you about how medical parole specifically has absolutely blindsided and traumatized my family. The impending release of my father's murderer has demolished any sense of peace or justice my family's been able to carve out after the brutal murder of my father in 1995. As Attorney Gulluni, District Attorney Gulluni told us, in 1997, John Stote was convicted of murder in the first degree with no eligibility parole. Even so, that monster has tortured us countless times in appeals and court appearances, and invented reasons why he shouldn't have to remain behind bars. Each and every time, my family has written letters, shown up in person, and begged whoever we could to please not be duped by this con artist. We've had to relive and retell our story, our horrible story, the disgusting story of how my father was brutally stabbed to death, how his body was weighed down in the Connecticut River, how the bloodied towels used to clean up the crime scene were disposed of at a rest stop on his way to attend a wedding on Cape Cod. We have endured and persisted because we believed all our heartache, suffering, and tears would be rewarded with justice. In fact, the law was on our side until this law was not. This insane, poorly written law with a giant loophole is allowing this disgusting monster and many others just like him to escape from their prison sentences. He's not even terminally ill. He has a bad back and limited mobility. He's overweight. He's pre-diabetic. He needs supplemental oxygen because of a bout he had with COVID. But don't worry, he's recovered. Even the doctors reported that he isn't expected to die from any of those ailments. He's just permanently incapacitated and not likely to pose a threat to society. Well, he does pose a threat to society, to me and to my family. He's unrepentant and he's not rehabilitated. He's being released to a skilled nursing facility where he could be the new roommate of any of our elderly or ailing friends or relatives. I have been defined as a victim of violent crime for 27 years. I am now being further victimized by the very system that was put into place to protect me. This is the definition of a travesty of justice for all of our families. It's a broken bill and it needs to be fixed. Thank you.
What you can just see, and what I, my staff, and my colleagues across the Commonwealth have experienced in our work with families of murder victims, is that the pain and trauma of their sudden and tragic loss is constant and enduring. This loss and its accompanying grief become their own life sentence. It is our contention that this law has created an unintended loophole that has given inmates convicted of first-degree murder who have been sentenced to life in prison without the possibility of parole a means to pursue that very possibility of parole, and in effect to sidestep their lawful and due sentences and to circumvent the specific statutory punishment for this crime. Moreover, it causes undue, and I would argue unjust occasions for families of lost loved ones to have to relive their trauma. Lawful and just murder sentences must have finality after appropriate appeals. Accordingly, we encourage a review by our legislature and the governor to correct and amend this statute to maintain justice and decency for victims' families and our communities. I certainly want to thank Jim and Maureen for speaking for their families. I want to thank everyone from the families here represented, from the Stote family, Maureen Regan Moriarty, Tricia Regan, from the Olszewski case, and the Welch family, Paula Welch Mackey, Paula Welch Burns, Danny Burns, Jim Welch, and John Welch, and also in the case of the murder of Mr. Brodeur. They are also here as well, and I want to thank them for their presence and support. Brian Batista, Michelle Batista, Dominic Batista, Kyle Broder, Robert Broder. I thank them all for their courage and for enduring everything they've had to endure, and for shining a light on the issues that clearly exist with this statute, and encouraging with me that this get corrected so their families and other families in similar situations don't have to unfairly continue to deal with this injustice. Happy to take any questions. Stephanie?
I'm not sure if it's appropriate for the DA or perhaps Maureen, but how has the legislative response been to this bill? How much have you gotten as well as support?
Yeah, certainly Maureen can speak however she wishes to. From my perspective, you know, there is apparently a bill that's recently been put in study. I think that this loophole has been known for some period of time, and there hasn't been a correction yet. So we're hopeful that with the collaboration of our local legislators and leadership in Boston, you know, certainly Governor Baker's leadership, that this will get corrected forthwith. I mean, the time has come. There's been enough suffering that I think with what we're highlighting today and what could possibly continue to happen, that this needs to get corrected immediately. Yes, sir.
Are you guys in talks, like with any local legislators here in Western Mass, or any of the families in talks with any local legislators, any meetings or anything like that?
Speaking on behalf of the DA's office, I've spoken with all local legislators just in the past couple days in particular about this press conference and the objectives, and encourage them to continue to collaborate with each other and to reach out to us. And I've conveyed how urgent this is. So I'm hopeful that, you know, given maybe an end to the pandemic, their return to the State House, and the attention we're bringing to this, and the need that is clear that this has to change, that we're going to work together and, again, work quickly to change this, which, again, is, I think, an obvious one. Paul?
So do you, just to be clear, do you support medical parole with the exception for the lifeless?
Listen, there's, I think, some other issues with this statute. You know, my first assistant district attorney is in the room here right now. She has dealt with almost all of the 47 petitions that we've gotten. Many of them are baseless. But I think what we're doing now is identifying the greatest need and the biggest flaw in this legislation, which is the elimination of the eligibility for first-degree murderers. It flies in the face of other statutes. It flies in the face of sentences that judges rightfully issue upon a plea or a jury's conviction. But fundamentally, you know, as Jim talked about, you know, medical parole is a concept and a law that exists in the federal system. It exists in many other states, and is designed to relieve the pressure for the housing facility and to provide decency for the person in those dying days to transition to a hospice facility or some other care facility. The breadth of this statute, the purview that's allowed, is far beyond what it should be. So the concept fundamentally of medical parole, I believe, is an acceptable one. But the way that this statute is written and how it's been allowed to be interpreted and exercised is totally inappropriate.
It's also been argued, in addition to those points that you made, that it's a cost savings to the taxpayers. And if you eliminate the lifers from that consideration, aren't you undercutting the cost savings?
Well, Paul, I have no concern for cost savings when you talk about justice, when you talk about lives being taken. And when in particular you think about the people who have committed these crimes, this is murder. It's a homicide with specific intent. And the courtesies that they seek, the decency that they seek in their own death, supposedly, was not afforded to the victims of their crimes. They were not given opportunities to say goodbye to family. They were not given dignity in their death. So when you talk about cost savings, it's irrelevant to me. What I'm concerned about is justice and decency for the memory of murder victims and the families that live on.
You had noted that, some of the examples you had mentioned, they blamed it on like COVID-19 or the pandemic. Is there a way to combat this loophole, considering the pandemic and everything?
Well, I think the loophole closing is very clear. It should not apply to those convicted of first-degree murder, irrespective of a pandemic or whatever reasons can be put forward. As it relates to other inmates, again, there's legitimacy there, right? Someone serving a drug sentence or someone serving a lesser sentence that has a term of years and they're at those final days or they have a serious permanent incapacity, fine. But again, our point, I think, is very clear that this should not apply to those convicted of first-degree murder.
Does anyone know where Stowe is going?
I do not at the moment.
We lost our rights. We lost our rights as victims to have any information about where he goes from here.
So he's been placed, yes, like that, or did you say him? Or you just don't even know?
I haven't been contacted yet.
He is out of a prison facility, though. He's in, presumably in some sort of care facility.
Skilled nursing.
Yeah.
With what ailment was he released? You say he was released originally for COVID, but then he recovered and he went back. So then what happened?
He was released originally because he was intubated with COVID, and the expectation of the commissioner was that he would expire from COVID. He was released. Over the course of months and months and months, he endured through COVID and recovered. It took basically an act of God to get the parole board to move, have a hearing, and reincarcerate him. His release now is as a result of permanent incapacities, which are ill-defined and frankly, less than impressive.
Limited mobility. He's overweight, pre-diabetic.
You know when he was released?
December 28th.
December 28th of this past year.
So nobody keeps track of him normally when somebody's paroled, there's some supervision that's involved.
Yeah, they're keeping track of him, and there's a plan that's put forward, and he's basically conditional to the parole board. He's on parole effectively. But what I think Ms. Regan is talking about is that we are not being communicated with. The family is not being told where he is or what his condition is. And that's been a consistent issue throughout, where the communication between the parole board and the DOC and the DA's office and victims' families has been spotty. And sometimes we're getting very short notice when we have to respond to these petitions, in which we also have to give notice to a family and communicate with them, and they're dealing with so much. And they're providing statements that might apply for some sort of hearing. We've had a handful of actual hearings, and some families, including the Brodeur and Batista families, have participated in that. But the communication system overall has not been great.
When do you hope to get something accomplished, like through the legislator, or have you guys ran to Governor Baker at all?
So I've talked to folks in the governor's office, including higher level people under Governor Baker and Lieutenant Governor Polito. You know, I think our hope is that this is done immediately. I mean, the timetable and when this bill can actually move is unknown to me, but I think that everyone has to act with urgency, given what we know and what we know is happening. Yes?
Is there a limited number that a convict petitions they could submit? Because they have all the time in the world in their hands, and it's just constantly. Seems like it's constantly, there's nothing better for them to do.
And taxpayers are paying for lawyers for these inmates to file these petitions. As you heard with Stowe, he filed a petition to the Superior Court, which came with an elaborate, series of pleadings that went to a Superior Court judge that eventually persuaded that judge. But yes, they have effectively court-appointed lawyers who the taxpayers are paying for to continually file these motions. And they're either motions for reconsideration or just further petitions. But as you heard, we've had multiple individuals file petition after petition after petition, often alleging very small changes to their health and sometimes no changes at all. But it causes my staff at very high levels to deal with this and to treat this as seriously as it needs to be treated. And it furthermore, and most importantly, causes families to have to react again and again and again and relive that trauma that comes with thinking about the possibility of this person getting out, and unduly so. So the system has a lot of flaws. Primarily, we're focused on the lifer issue and that they should not be eligible. Thank you all for coming. Appreciate it. Yeah, Paul, one last one.
Could I ask Jim Welsh a question?
It's up to Jim.
Well, you were in the legislature when this passed. Did this issue ever come up with what to do with the life?
Yeah, so...
Could I get you on the microphone?
Oh, sure. So, just the brief history, the medical parole piece of this was passed, and as the DA mentioned, in 2018 as part of criminal justice reform. I think in many people's eyes, well-intentioned, as we said. You think of a scenario where a person is at the end of their life and they need to be placed in a hospice situation, and I think most people would agree that, for all people involved, that is the best situation. That is, medical parole can happen in that situation. When COVID happened, correct me if I'm wrong, DA, but I think that's when the big spike of folks that were applying for medical parole started to happen, and obviously with COVID being something new for everybody to deal with, nobody had thought about a situation like COVID before. So during, I was still in the legislature in 2020 when we did our police reform legislation. So I actually filed an amendment in the Senate version of the police reform debate to eliminate the ability to even apply for medical parole for anyone convicted of first-degree murder without the possibility of parole. Unfortunately, my efforts were not successful in the Senate. It was ruled that it was not, basically it was ruled out of order, meaning the subject matter did not, the Senate president did not feel the subject matter was relative to the police reform legislation. I certainly would make an argument that it was, and I did, and I challenged the chair at the time, and unfortunately did not succeed. But we have to endure. We have to continue to make the case that this loophole needs to be closed and needs to be fixed. And one thing to keep in mind, in terms of legislation, an actual traditional piece of legislation is not the only path that this can take. There's many vehicles that legislators have the option to amend. For example, the state budget is coming up in the next few months. There's many crafty legislators out there. I certainly took advantage of it myself. When a vehicle is moving through the legislature and is going to be passed, you can make policy changes in any type of piece of legislation, and I would suggest that this, for a situation that needs to be addressed as quickly as this, that it probably should be addressed in another vehicle of legislation that's already moving as an amendment, whether it's the budget or something else. That can be done. That can be done. It's been done for decades, if not centuries, here in Massachusetts. So don't take the answer when legislators tell you, and I was one, when legislators tell you that the bill is held up. There's plenty of opportunities for a policy change in any type of piece of legislation that goes through.
Thanks.
Any other questions? Thank you. Thank you.
Thank you.